The Supreme Court has a 40-year jurisprudence, starting from Tufo and Attorney General, affirmed in 1996 by the J.H. Mensah case, in which the Supreme Court stayed true to the cause by deciding that it does not interfere in happenings within Parliament. Therefore, in terms of the internal administration of Parliament, the Supreme Court says it is not interested. And the reason for that, as I mentioned earlier, is that the court seeks to maintain and ensure inter-branch harmony by avoiding conflict, because they both have different jurisdictional mandates. The court doesn't want to go inside Parliament. In fact, in the Tufo case, the expression used was happenings in Parliament represent a closed book scenario. They are not going to open the book. And so if the court should stay true to its original jurisprudence, both in Tufo and in J.H. Mensah, the expectation is that the court's mandate, in terms of any application brought before it now, will have to be limited to determining the correctness by which, or rather, in determining the propriety by which the Speaker exercised his mandate. That means the Supreme Court can look at whether the Speaker exercised his mandate properly, whether the circumstances for exercising the mandate has arisen, whether the scope and jurisdictional boundary of that mandate has been respected, and the Speaker has not gone beyond that.
Right.
What the Supreme Court cannot do in terms of its own jurisprudence is to determine the correctness of the Speaker's interpretation of the law. The Supreme Court may not want to do that because Article 97 is an authority that is vested in the Speaker as as the ultimate presiding officer of the House.
Right.
And so the Speaker has a mandate to take decisions by way of determining things that affect his mandate. But the court can decide whether or not the Speaker has gone beyond his authority. For example, whether the circumstances for the Speaker exercising his mandate under Article 97 hasn't arisen, but the Speaker went ahead nonetheless to exercise his power. The court can say you have acted improperly. What the court cannot do is to second guess the Speaker by determining whether or not his interpretation of the law, in terms of the determination of vacancy, whether the Speaker has properly interpreted that. So it's a very fine line.
Prof,
And
does
that
it make
fine
a
line
difference?
Is one that the court itself established, as I indicated, 40 years ago, reaffirmed subsequently in other cases.
Right.
And so it's very, but it's important for me to add that right now, the caveat, that the court has the jurisdiction to not respect its own jurisprudence. The Constitution allows the court for the court to go back on its own jurisprudence. But this is not something the court does lightly. Usually when they have to do that, they will marshal